VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
Let us try to analyze ano ang ibig sabihin no progressive scheme of taxation sa Constitution. Ano ang ibig sabihin nito? Okay, ang ibig lang sabihin nito is whenever the Congress is enacting a tax law, all right, they should try their best to address their intention to the ability to pay principle of the people. Okay? So they should come up with many rates from the lowest to the highest. So that is what we call progressive scheme of taxation. So you will see na ang ating income tax tumutugma sa progressive scheme of taxation because sa tax code, ang income tax rate ng individual taxpayer
action by which a party sues another for enforcement or protection of a right or prevention or redress of a wrong. So what are the keywords here? Enforcement, protection of right, prevention or redress of wrong. Tandaan nyo, enforce, protect, right, prevent, redress, wrong. Okay. Remedy by which a party seeks to establish three things. Status, right, particular fact. Okay. Ano yung sa television, yung commercial? SRP. Ano yung SRP? Suggested retail price. So tandaan nyo, to establish
This is before the amendment. And for every allegation, it should be supported because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish to the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
what is our definition of the practice of law? We have three very good definitions of the practice of law. The practice of law is a profession. It is not a business or trade. Lawyering is not primarily meant to be a money-making. It is not a capital that necessarily yields profits. Duty to the public service and to the administration of justice should be the primary consideration of lawyers, and gaining a livelihood is a secondary consideration. Very good definition, easier said than done. So our primary consideration is to administer justice. Gaining a livelihood is a secondary consideration only for us lawyers. Another definition of the practice of law is
in Spouses Minjola versus Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
provisions in the Constitution indirectly affecting taxation. One is due process. And there are two aspects of due process. Procedural due process and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act a violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.
Now take note under Rule 58. There are two kinds of injunction: preliminary mandatory injunction, preliminary prohibitory injunction. Now, lifetime of a TRO issued by the RTC, by the Court of Appeals, and by the Supreme Court. So, if it is issued by the RTC, you have 20 days. Within the 20-day period, then there shall be a hearing. The hearing is mandatory as regards to the application for preliminary, mandatory, or prohibitory. Now, after the lapse of the 20-day period and there is no injunction issued, it becomes pactus officio. Now, as far as Court of Appeals is concerned, the lifetime is 60 days. Now,
involved is what appears to be a discriminatory act on the part of government or agents of the government. The proper right to invoke there is the right to the Equal Protection Clause. Because remember, the right to the Equal Protection Clause is a right against any kind of discrimination or discriminatory act on the part of government. So that is a broad formula. So if what is involved, I repeat, is an act of government that appears to be arbitrary, whimsical, capricious, oppressive, unreasonable, confiscatory, and you want to challenge that, you invoke your right to due process law. On the other hand, the Equal Protection Clause is a guarantee against any kind of discrimination or discriminatory action.
First, let us speak of the principles of generality and territoriality. Remember that questions about these two principles were asked in the 2015, 2017, 2018, and 2019 bar examinations. Okay? So far as generality is concerned, consider the persons which are exempt from the general application of Philippine criminal law by virtue of the principles of public international law, and the person exempt from criminal from the application of Philippine criminal law are the sovereigns, chief of states. We have ambassadors, ministers plenipotentiary.
In the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
Party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the purpose.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
involved is what appears to be a discriminatory act on the part of government or agents of the government. The proper right to invoke there is the right to the Equal Protection Clause. Because remember, the right to the Equal Protection Clause is a right against any kind of discrimination or discriminatory act on the part of government. So that is a broad formula. So if what is involved, I repeat, is an act of government that appears to be arbitrary, whimsical, capricious, oppressive, unreasonable, confiscatory, and you want to challenge that, you invoke your right to due process law. On the other hand, the Equal Protection Clause is a guarantee against any kind of discrimination or discriminatory act.
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual class and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is a champion debater, educator, and a public servant. He finished a major in political science and Bachelor of Laws from the University of Santo Tomas. As a student, he represented his alma mater in various local and international debating competitions, some of which include 2015 Foreign Direct Investments International Arbitration Moot King's College London and United Kingdom, First Asian Universities Debating Championship in 2004, quarterfinalists and best speaker of ANC's Square Off, the CVC Law Debates Season 2. From 2013 to date, He serves as the advisor of various co-curricular organizations at the University of Santo Tomas, namely, UST Faculty of Civil Law Debate and Moot Team, UST Bar Operations, and the UST Political Law and Public International Law Golden Notes. He is a professor at UST Faculty of Civil Law, UST Faculty of Arts and Letters, and Arellano University School of Law. He has published articles and delivered lectures in various fora. He served as Court Attorney 6 at the Office of Associate Justice Roberto A. Abad and the same time served as Committee Secretary of the Committee on the Revision of the Rules of Civil Procedure in December 2012 to September 2013. Currently, he works in various capacities at the Tourism Infrastructure and Enterprise Zone Authority, namely, Board Secretary 5, Compliance Officer, and Officer in charge of the Legal Department. Please welcome Professor Al Conrad B. Espaldon.
So, I am Professor Al Conrad B. Espaldon, and welcome to this free online lecture brought to you by Villasis Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like the VLC Facebook page and share this FB live session. Host a watch party via FB and tag your friends now, and together learn at the comfort of your homes. Before we start, please comment VLC. Okay, thank you very much. Okay, so for today, I'll be discussing some basic principles under public international law. So we'll be starting with the sources of international law. Under the ICJ statute, or the International Court of Justice statute, it enumerates the sources of international law. It classified two major sources of international law, the primary sources and the subsidiary sources. So let's first discuss the primary sources. Article 38 of the ICJ statute states, international conventions, whether general or particular, establishing rules expressly recognized by the contesting states, otherwise known as treaties or conventions, international custom as evidence of a general practice accepted as general principles of law recognized by civilized nations. So these are the primary sources of international law under the ICJ statute. How about the subsidiary sources? We have judicial decisions and the teaching of the most highly qualified publicists of various nations. Article 38, paragraph 2 of the ICJ statute also recognizes the authority of the court to decide the case using the principle of ex equio et bono. But under this principle, the court can only decide the case using this if the parties agree thereto. Okay, so let's discuss one by one the primary sources of international law, starting with treaties or international conventions. So what are treaties? Treaties are agreements between and among states by which parties obligate themselves to act or refrain from acting according to the terms of the treaty. So this is the generic definition of a treaty. However, under the Vienna Convention on the Law of Treaties, it provided a specific and technical definition of the said term. Under the VCLT, it defines treaty as it is an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. So from this definition, we can say the elements of a treaty under the VCLT is that number one, it has to be an international agreement concluded between states. So for it to fall under the definition of the VCLT, the treaty has to be between two states. It cannot be a treaty between a state and an international organization, for example, or between or among international organizations. The parties to a treaty under the VCLT must be, remember, states, okay? Number two, it has to be in writing. Again, it has to be in writing, okay? For it to fall under the VCLT, the coverage of the Vienna Convention on the Law of Treaties, it has to be in writing. Although there could be oral treaties or verbal treaties, which is also recognized by international law, but any controversy arising from the said treaty will not be covered by the VCLT because the VCLT has a technical definition of what a treaty is. It has to be in writing. Next, it must be governed by international law. What does this mean? It simply means that the provisions of the treaty are governed by the rules of international law. It cannot be governed by the rules of municipal laws between or among Japan, the Philippines, Malaysia, Indonesia, etc. was entered into. And now controversy arose based on that treaty. And if you read the treaty, it states there that any controversy arising from the interpretation of this treaty will be resolved using the laws of Japan. So that's under the provision of that said treaty. The question is, can the parties use the VCLT as a way of solving any problem as regards the interpretation of the said treaty? Answer, no. Why? Because according to the VCLT, it has to be governed. The problem I gave you, it was very specific. It has to be governed by the municipal laws of Japan. Okay, you get it? And then whether embodied in a single instrument or in two or more related instruments and whatever its particular designation. So regardless of what you call the said treaty, if you call it an agreement, a convention, or a protocol, in essence, it will still be a treaty if it falls within the definition of the VCLT. So these are the elements of a treaty under the VCLT. Okay? And there are two kinds of a treaty: lawmaking treaties or normative treaties, and treaty contracts. What's a lawmaking treaty? A lawmaking treaty or normative treaties universal application and are intended for future and continuing observance. And these are the multilateral treaties, meaning to say a large number of states have entered into it. Okay, that's why it becomes a norm between and among the member states because of the large number of states who have participated or who have signed the said treaty. Okay. While treaty contracts, they resemble contracts in that they are concluded to perform contractual rather than normative functions. It usually concerns the regulation of a narrow area of practice between two states. So usually these are bilateral treaties. Okay, examples of which are trade agreements. Such treaties may lead to the formation of general international law through the operation of the principles governing the development of customary rules in the following ways. So, under this kind of a treaty, this bilateral treaty or treaty contracts can eventually ripen by international law if it undergoes the following ways. Okay? A series of treaties, each of which lay down similar rule, may produce a rule of customary international law to the same effect. So, for example, two countries have entered into a treaty, and then other countries, after observing that the treaty entered into, for example, by State A and State B, learned that it was a good treaty governing the relations of these two countries. Other countries adopted it or copied it. So in that way, if a large number of states have also copied it, then it could eventually ripen into a customary international law, provided that the other elements of customary international law are also followed. Okay? A rule contained in a treaty originally concluded between a limited number of parties may subsequently be accepted or imitated as a general rule. So almost the same as the discussion a while ago. Next, a treaty may have evidential value as to the existence of a rule which has crystallized into law by an independent process of development. So a treaty could also be an evidence of an existing customary international rule. So for example, the Vienna Convention on Diplomatic Relations, which grants, for example, diplomatic immunity to different kinds of diplomats. The immunity enjoyed by diplomats, it's based on customary international law. But this was eventually codified and crystallized into what we call the Vienna Convention on Diplomatic Relations. So customary international law on diplomatic immunity, it was converted or codified into the Vienna Convention on Diplomatic Relations. So what are the essential characteristics of treaties? it becomes binding on the parties to it by virtue of their consent. So remember that one, before a party can become, before a state, before a treaty can be binding on a state, that state must have given its free consent. It must give its free consent, because absence of consent, a state cannot be bound by a treaty. Or if the state has given its consent but it was vitiated, then that could eventually be a ground to ask for the nullification of the said treaty because the consent was vitiated. Okay? While treaties will in most cases be written instruments concluded between states, the term applies equally to unwritten agreements and to agreements between states and international organizations and between international organizations. So this is what I've been saying a while ago. A treaty could be verbally made or in writing. It could also be between states and an international organization or between two international organizations. But remember the discussion a while ago regarding the definition of a treaty under the VCLT. These kinds of treaty will not be governed by the VCLT because they have a different kind as opposed to the VCLT. So if you want to apply the provisions of the VCLT to a particular treaty, that particular treaty must fit the definition provided by the VCLT. But it does not mean that these kinds of treaty are no longer treaties. They are treaties in its generic form. But they are not a treaty under the definition provided by the VCLT. Okay? Okay. So that's a treaty, which is a source of international law. Let's go to international custom or customary international law. What is this? Our rule of CIL is one that, whether or not it has been codified in a treaty, has binding force of law because the community of states treats it and views it as a rule of law. In contrast to treaty law, a rule of customary international law is binding upon a state, whether or not it has affirmatively assented to that rule. So one of the basic differences of an international custom from that of a treaty is what? A while ago, we've said that for a treaty to be binding on a state, the state must give its free consent. It must give its free consent. Absence of consent, a treaty will not be binding on a state. Are we clear? But in customary international law, once a rule ripens into a CIL or customary international law, it will be binding on all states, even to those states which has not affirmatively assented to that rule. Are we clear? So that's one of the basic differences between customary international law and a treaty as a source of international law. Okay, let's discuss the elements of a customary international law. A customary rule requires the presence of two elements. Number one, the objective element, or the general practice or state practice, and the psychological element, or what we call opinio juris sive necessitates, or simply opinio juris. Okay. What's the objective element or state practice? This is normally constituted by the repetition of certain behavior on the part of a state for a certain length of time which manifests a certain attitude without ambiguity regarding a particular matter. Evidence of state practice may include a codifying treaty if a sufficient number of states sign, ratify, or accede. However, remember this one, no particular duration is required for practice to become law. On some occasions, instant customs come into existence. For that reason, a few repetitions over a short period of time may suffice, or many over a long period of time, or even no repetition at all insofar as an instant custom is concerned. So, sabi natin kanina, for there to be state practice, of course, there has to be a what we call this. There is a repetition for a certain length of time. Okay, but the question is, for what is the length of time required for it to ripen into a customary international law. Okay? ICJ did not, several rulings of the ICJ has not or have not given a specific time frame as regards when a particular custom can ripen into a customary international laws. ICJ said it's a case-by-case basis. Okay? How about the number of states which must practice this one for it to ripen into a customary international law? Same. ICJ did not also give categorical answer. According to ICJ, there has to be a sufficient number of states which must practice the said practice to ripen into a customary international law. A minimum number, ICJ did not give. Again, it's a case-by-case basis. Okay? So you just have to look at the surrounding circumstances of each case. In fact, if you look at some experts' opinion on this matter, sabi nila, no particular duration is required for practice to become law. On some occasions, there is even what we call an instant custom, wherein even if there is just a few repetition or just a single conduct as regards a practice, it could become a customary international law, which is known as instant custom. But for this to happen, however, the shorter the time, the more extensive the practice would have to be to become law. A practice uniform in particular with regard to the affected states, but complete uniformity is not required. So if it's an instant custom, so there is a short period of time wherein this has been practiced, may kapalit siya. May requirement na kailangan. The requirement is that the practice must be extensive, meaning to say a large number of states have been practicing it. Okay, and which states must be practicing the said practice or custom? A practice must be constant and uniform, in particular with regard to the affected states. So states which are also facing the said circumstance must be practicing it uniformly and constantly. But remember, complete uniformity is not required. Okay? Substantial uniformity is enough, but complete uniformity is not required under international law. It would suffice that conduct is generally consistent with the rule and that instances of practice inconsistent with the rule are treated as breaches of that practice is usually mean widespread but not necessarily universal adherence to the rule. Indeed, custom may be either general or regional. General customs apply to the international community as a whole, while local or regional customs apply to a group of states or just two states in their relations inter se. When we say regional customs, so for example, a custom that has been generally observed or extensively observed by a group of states, for example, the ASEAN region, the members of the ASEAN region, okay? Okay, elements which must be present before a principle of international custom can be found to be established. First, concordant practice by a number of states with reference to a type of situation falling within the domain of international relations. Next, continuation of repetition of the practice over a considerable period of time. Third, conception that the practice is required by or consistent with prevailing international law, and general acquiescence in the practice by other states. Let's go to the subjective element or the opinio juris sive necessitatis. This is the most important element of customary international law. What is this? To assume the status of CIL, the rule in question must be regarded by states as being binding in law, that they are under a legal obligation to obey it. The main purpose of the opinio juris is to distinguish between customary rule and mere usage followed out of courtesy or habit. So if it's just a mere practice observed by states, but states are merely practicing it without the belief that they have a legal obligation to practice it, then that's just a mere usage. But if they're practicing it with the belief that they have the legal obligation to obey it, then that could become customary international law. That is the element or the opinio juris. Okay? Put another way, opinio juris is the conviction of a state that it is following a certain practice as a matter of law, and that were it to depart from the practice, some form of sanction would or ought to fall on it. So even, for example, there's no law or treaty that mandates a state to practice a particular custom, but states are still practicing it out of the belief or conviction that they have to do so, then that is what we call opinio juris. Okay? Okay, so how can we prove the existence of CIL? What evidence or pieces of evidence that can show that a certain usage or a practice has already ripened into customary international law? CIL is shown by reference to treaties, decisions of national and international courts, national legislation, diplomatic correspondence, opinions of national legal advisors, and the practice of international organizations. Each of these may be employed as evidence of state practice, opinio juris, or both. In the North Sea Continental Shelf case, the ICJ stated that the party asserting a rule of CIL bears the burden of proving that it meets both requirements. Okay, so the party alleging that a particular usage or practice has already ripened into a customary international law has the burden of proving that it is indeed a CIL. Okay. A while ago, we've said that a treaty becomes binding because a state has given its consent. Absence of consent, it could not be binding on any state. Okay? But there is an exception to that rule, wherein even if there is no consent, a treaty can still be binding on a state if the said treaty is or has ripened into a customary international law. So if the treaty eventually ripens into a customary international law, or the treaty is a mere codification of customary international law, then that can still be binding even on states which have not given their consent. That's the beauty of customary international law. Even if you have not given your consent, it will still be binding on you. You get it? So I'll repeat. Customary international law, it binds countries even if they have not given their consent. You get it? So general rule, for a treaty to become binding, there has to be consent. Exception, a treaty which codifies customary international law, or a treaty which eventually ripens into a customary international law. You get it? But there is an exception to the exception. So what do you think is that exception? What do you think is that exception? Okay, the exception is the persistent objector rule. The persistent objector rule. If a state is able to prove that it is a persistent objector, then customary international law will not be applied to it. It cannot be forced to comply with a customary international law if it can prove that it is indeed a persistent objector. Okay? So what is this all about? If during the formative stage of a rule of customary international law, a state persistently objects to that developing rule, it will not be bound by it. Once a customary rule has come into existence, it will apply to all states except any persistent objectors. However, a state, in order to rely on the said rule, must prove the existence of the following requisites or elements. First, it has to raise its objection at the formative stage of the rule in question. Second, it must be consistent in maintaining its objection. And lastly, it has to inform other states of its objection. This is particularly important with regard to a rule which has been almost universally accepted. If a state remains silent, its silence will be interpreted as acquiescence to the new rule. The burden of proof is on the objecting state. So these three requisites must be present before one can be considered as a persistent objector. You get it? Again, these three elements must be present before one can be considered as a persistent objector. Okay. So, general rule, there has to be consent for a treaty to become binding. Exception, customary international law. So even if you have not given your consent, the treaty will still be binding to you if the treaty is a codification of customary international law or the treaty eventually ripens into a customary international law. The exception to the exception is if the state is a persistent objector. Okay? However, later on, we will learn that there is also an exception to the persistent objector rule. Later on, we will discuss that. Okay. So we've already discussed two of the primary sources of international law. The question is, which between the two, can the two coexist? There is a conflict between a customary international law and a treaty. Which will govern between them? Is there a hierarchy between the two? Which is higher between the two? So these are just some of the questions that we might be asking ourselves when we discuss the primary sources of international law. Okay, so let's try to answer those questions. The relationship between treaties and international custom. They coexist, develop each other, and sometimes clash. If there is a clash between a customary rule and a provision of a treaty, then because they are of equal authority, except when the customary rule involved is of a jus cogens nature, whereupon, being superior, it will prevail, the one which is identified as being the lex specialis will prevail. The lex specialis will be determined contextually. So what does this mean? Remember this one, there is no hierarchy in the primary sources of international law. They are of equal authority. Since they are of equal authority, in case there is conflict, there's no default rule that this one will prevail over the other. Because, again, they are equal. You get it? Okay. But in case there is a conflict between the two, between a treaty and customary international law, which will prevail? We apply the rules on statutory construction. So, what are the rules? Diba? First, you've learned in your first year, in your statutory construction class, that if there is a conflict between two laws, what do? You first try to reconcile it, right? You have to first try to reconcile it. In case they cannot be reconciled, then you use the lex specialis rule. What is this rule? Special law prevails over a general law. Special law prevails over a general law. And another principle that you could use is what? Later law or the newer law or newer treaty prevails an older one. You get it? So these are the two principles that you could use to determine which between a treaty and a customary international law would prevail just in case there becomes a conflict. Just in case there becomes a conflict between the two. But remember this one. Remember this one. You do not apply these rules. You do not apply these rules if the customary rule involved has already ripened into a jus cogens norm. If it has ripened into a jus cogens norm. Because if the customary rule has ripened into a jus cogens norm, then by all means, the customary rule which has ripened into a jus cogens norm will prevail over a treaty. And that's an absolute rule. That's an absolute rule. That jus cogens will always prevail. Why? Because from the very definition of jus cogens, it does not permit any form of derogation. It does not permit any form of derogation. Therefore, if there is a conflict between a treaty and a customary international law, and the customary international law involved has evolved into a jus cogens norm, then customary international law will prevail. Are we clear? So a while ago, I told you there is an exception to the persistent objector rule. Sabi natin kanina, if a state who is not a party to a treaty is not bound by the said treaty. But if the treaty is a codification of customary international law, or the treaty has ripened into a customary international law, then even those states who have not given their consent will be bound by the said treaty. Exception is if you are a persistent objector. Get it? If you are a persistent objector, then you are not bound by a customary international law. What's the exception to that rule? If the CIL has evolved into a use cogens norm, if the CIL has evolved into a use cogens norm, even if you are a persistent objector, you become bound by the said customary international law because it is already a use cogens norm. Just like what we've said a while ago, if it is a use cogens norm, it does not permit any form of derogation. It does not permit any form of derogation. Therefore, you become bound by it. You have to observe it. Are we clear? Okay. Okay. Use cogens and rules creating erga omnes. You have to be familiar with these two rules or with these two principles, because if you look at previous bar exam questions, if there are questions as regards public international law, most of the time they relate to use cogens and erga omnes obligations. Okay? So what's a use cogens norm? Use cogens rules represent the highest source in the informal hierarchy of sources of international law, or in the normative sources of international law. The main difference between a rule of use cogens and a rule that creates an obligation erga omnes is that all use cogens rules create erga omnes obligations, while only some rules creating erga omnes obligations are rules of use cogens. So in short, all use cogens are erga omnes obligations, but not all erga omnes obligations are use cogens norms. Okay? Further, with regard to use cogens obligations, the emphasis is on their recognition by the international community as a whole, whilst with regard to obligations erga omnes, the emphasis is on their nature. The latter mentioned embody moral values which are of universal validity. They are binding because they express moral absolutes from which no state can claim an exemption, whatever its political, economic, and social organization. The legal consequences of violations or rules creating erga omnes obligations differ from those for breach of the rules of use cogens, in that, in addition to the consequences deriving from breach of erga omnes obligations, further consequences specified in Article 53 of the VCLT follow from violations of the rules of use cogens. So, if a treaty violates use cogens norm under the VCLT, the said treaty will be voided. The said treaty will be voided. Okay, that's the consequence if a treaty violates a use cogens norm. Okay. Let's skip some discussions. I just have to continue discussing use cogens. Okay. What is a use cogens and what is an erga omnes obligation? Use cogens norm is a norm which states cannot derogate or deviate from in their agreements. Basically, if you enter into a treaty or an agreement with another country or several countries, you can certainly agree anything that you want. Anything under the sun can be agreed upon. That because the only rule is that both parties or all parties to the said agreement must agree thereto. The only exception is what? You cannot agree on something that violates use cogens norm. You cannot agree on something that violates use cogens norm. Why? Because if you do that, that treaty will be voided. Because remember, in use cogens, it does not permit any form of derogation. You get it? In fact, under the VCLT, there are two consequences if a treaty violates a use cogens norm. So for example, you entered into a treaty now, and the said treaty is in violation of use cogens norm. What is the consequence? The said treaty will be voided. The said treaty will be voided. or is void. Another instance. Example, you enter into a treaty now. And at the time that you entered into a treaty, it does not violate any form of any use cogens norm. It does not violate any use cogens norm. So it's valid, right? Okay. But if several years from now, a new use cogens norm emerges. And now, the treaty that was entered into years ago is now in conflict with this new use cogens norm. What would be the effect? What would happen to the treaty? Answer, the treaty becomes void. Because it now violates a use cogens norm. Again, use cogens does not permit any form of derogation. Therefore, even if the treaty was entered into several years ago and at the time it was entered into, it does not violate a use cogens, but eventually a new use cogens emerge and it's now in conflict with each other, the treaty will be voided because it is in conflict with a use cogens norm. Okay? It is therefore a mandatory norm and stands on a higher category than a use dispositivum norm, which states can set aside or modify by agreement. Okay? It reflects the most fundamental values of international society and thus stand at the apex of the normative pyramid of the international legal system. Examples of a use cogens norm: the prohibition against the use of force, the law on genocide, the principle of self-determination, principle of non-racial discrimination, crimes against humanity, prohibition against slavery and slave trade, and piracy. So these are just some examples of use cogens norm. Let's go to obligation erga omnes. This is an obligation not contractual in nature of every state towards the international community as a whole. All states have a legal interest in its compliance, and thus all states are entitled to invoke responsibility for breach of such an obligation. So when we say obligation erga omnes, this is an obligation of a state towards the international community as a whole. And the obligation is not because it is contractual in nature, but because of the very nature of the obligation. By the very nature of the obligation, you have to observe it. You get it? Okay. Its performance does not concern only the state to which the obligation is owed. So for example, in the context of a bilateral investment treaty, the only state that does care about the breach of an obligation under the treaty would be the other contracting party. So meaning to say, it's only the injured party. Okay? On the contrary, obligations erga omnes are of such nature that all states have a legal interest in their performance. Hence, in the event of breach of such obligation, all states are entitled to raise the issue before political organs and invoke the responsible wrongdoing state. Okay? So, let's go to ordinary contractual obligations. So, for example, there are two parties to a contractual obligation. If the contract was violated, who has the legal standing to ask for a remedy from a court? Obviously, it's the injured party, and no other party can participate in the said case, or no other party can invoke the right of the injured party. It's only the injured party who has the legal standing to what? To call out the other party for breach of the obligation, right? Okay. But when it comes to obligation erga omnes, even if, for example, State A committed a violation on the rights of State B. State A, for example, committed genocide on State B. In this case, class, it's not only State B who can what? Go before political organs of the international community to seek or invoke responsibility of State A. Even State C, D, E, and other states can invoke the responsibility of the wrongdoing state. Why? Because what was violated by State A here is not only a violation directed against State B, but against the international community as a whole. Remember, if it's an obligation erga omnes, it is an obligation of a state towards the international community as a whole. So even if the injury was directed only to State B, other states can call the attention for violating an erga omnes obligation. You get it? You get it? So in short dito, pwedeng mangialam yung ibang bansa. You get it? Because what was violated here was an erga omnes obligation, an obligation of a state towards the international community as a whole. Okay? What are examples of erga omnes obligation? Outlawing of acts of aggression and of genocide, as also form the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. Just like what we've said a while ago, pag nakita mo almost the same yung example ng erga omnes obligation and use cogens. Why? Because all use cogens norm are erga omnes obligation. You get it? Okay. Let's go back. Okay, so we've already discussed that. Okay, let's go to another principle, another primary source of international law. This is the general principles of law, the general principles of law. Okay? Reference to such principles is to both those which are inferred from municipal laws and those which have no counterparts in municipal law and are inferred from the nature of the international community. If there is no treaty relevant to a dispute, or if there is no rule of CIL that can be applied to it, the ICJ is directed under Article 38 of its statute to apply general principles of law. What does this mean? It means to say that the ICJ may only use general principles of law in case there is an absence of an applicable treaty or an applicable CIL. You get it? Because if there's an applicable treaty or an applicable CIL, then you use this one. You use this one. So you get it? But in case there is no applicable treaty or no applicable CIL, then that's the only time that the ICJ may proceed to general principles of law. Okay? And general principles of law may be referred from municipal laws, and those which have no counterpart in municipal law and inferred from the nature of the international community. Simply stated, such principles are gap filler provisions utilized by the ICJ in reference to rules typically found in domestic courts and domestic legal systems in order to address procedural and other issues. So again, when we say general principles of law, these are gap filler provisions because they can only be used by the ICJ in case of absence of an applicable treaty or an applicable CIL. Examples of which are burden of proof, admissibility of evidence, waiver, estoppel, the doctrine of unclean hands, necessity, and force majeure. Okay, so that's for the general principles of law. Now let's go to the subsidiary sources of international law, the subsidiary sources. These categories describe as a subsidiary means of finding law. Judicial decisions and scholarly writings are, in essence, research aids for the court, used, for example, to support or refute the existence of a customary norm, to clarify the bounds of general principles of customary rule, or to demonstrate practice under a treaty. Okay, let's go to judicial decisions. As there is no binding authority of precedent in international law, international court and tribunal cases do not make law. Judicial decisions are therefore, strictly speaking, not a formal source of law. However, they clarify the existing law on the topic and may, in some circumstances, create a new principle in international law. They can also be considered evidence of state practice. So just like Supreme Court decisions or our jurisprudence, technically they are not laws, right? But they have the force and effect of a law because they are the reflection or interpretation of a law. Okay? So, just like judicial decisions, it can also become a subsidiary source because it what? It evidences the existence of a customary international law, for example. You get it? And what the next question is, what kind of judicial decisions can be considered as a subsidiary source? Is it limited only to decisions of international tribunals, or we can also use decisions of municipal courts? Okay? Answer? If you look at the provision of the ICJ statute, it does not specify what kind of judicial decisions. Since it does not specify what kind of judicial decisions, then it simply means that when we say judicial decisions, this could mean what? Decisions of international tribunals or decisions of municipal courts. You get it? That's why if you read some ICJ decisions, from time to time, they are citing decisions of the US Supreme Court or the Canadian Supreme Court or the decisions of the European Court of Justice. You get it? Okay, because judicial decisions does not specify which between international decisions of international tribunals or municipal courts will be applicable. Okay? Okay. Article 59 of the ICJ statute provides that decisions of the courts have no binding force except for the parties and in respect of the case concerned. This provision shows that decisions of the ICJ have no binding authority, and ICJ does not make law. What does that mean? Unlike Supreme Court decisions wherein we have the doctrine of stare decisis or the doctrine of precedents, wherein decisions of the High Court will be applied to all similarly situated cases. So if a case has been already decided by the Supreme Court and a new dispute or a new controversy arose with similar circumstances as that have been decided already by the Supreme Court, lower courts are duty-bound to apply the decision of the Supreme Court, right? But in the ICJ, there's no such thing because the ICJ decision will only apply between the parties. So what does it mean? The ICJ can deviate from the previous decision, from their previous decisions. You get it? Because again, the doctrine of stare decisis apply to the ICJ. In fact, even in our Philippine Supreme Court, it does not apply. That's why from time to time, the Philippine Supreme Court reverses their previous decisions because the doctrine of stare decisis simply does not apply to the highest court of the land. You get it? So similar to the ICJ, their decisions have no binding effect, except to that for the parties and in respect for the case concerned. You get it? Okay. It only binds the parties to the said case or controversy. In practice, however, the ICJ will follow the previous decisions so as to have judicial consistency, or if it does not follow, the court will distinguish its previous decisions from the case actually being heard. So, although there is no rule that requires ICJ to follow their previous decisions, in fact, Article 59 of the ICJ statute is explicit that the doctrine of stare decisis does not apply to them. But in case the but in practice, ICJ usually observes and follow their previous decisions for judicial consistency. Okay? Okay. The next kind of a subsidiary source is the writings of publicists. This source generally only constitutes evidence of customary law. However, learned writings can also play a subsidiary role in developing new rules of law. Requisites to be considered as a highly qualified publicist of the various nations. There are two. First, the writing of that particular publicist must be fair and impartial representation of law, and he or she must be an acknowledged authority in the field. Examples of persons who are considered as highly qualified publicists of the various nations are Grotius, Lauterbach, Oppenheim, Crawford, House, Shaw, and Brownlee. So they are just some examples of highly qualified publicists of the various nations. Okay, so these are the primary sources and the subsidiary sources of international law. Okay. We've already discussed that. Okay. Okay. I'd like to call your attention to Article 103 of the UN Charter. Under this provision of the UN Charter, in the event of a conflict between the obligations of the members of the United Nations under the present Charter and their obligations under any other international agreement, their obligations under the present Charter shall prevail. So, what does this mean? So even if you've entered into a treaty with other states and you have an obligation under the treaty, but if the United Nations Security Council, for example, has released a rule or a resolution which has to be applied to all members, but that resolution is in conflict with your existing treaty obligation with another country, which between the two will prevail? Answer, under Article 103 of the UN Charter, your obligation under the UN Charter will always prevail. You get it? So if you breach your obligation under the treaty you've entered into with another state, you cannot be faulted with that because you merely followed the order or resolution of the UN Security Council, which under 103 of the UN Charter, you are mandated to comply. You get it? You get it. So again, if there's a conflict between your treaty obligation with another state and your obligation under the UN Charter, your obligation under the UN will have to prevail. You get it? You will have to prevail. Okay. So remember, obligation under the UN Charter, you have to always comply with it. You get it? But there's an exception to that rule. What is that? What is that? If the resolution passed by the UN Security Council is in conflict with the use cogens norm. If the resolution of the Security Council is in conflict with the use cogens norm, that order or resolution of the UN Security Council is considered void. Why? Because again, use cogens norm, it does not permit any form of derogation. So you are not duty bound to comply with the order of the UN Security Council. Are we clear? Okay. Let's proceed to another topic. Okay. Another topic that we have to discuss, or one of the most interesting topics now in public international law, particularly as regards what's happening in the South China Sea, is the case of the Republic of the Philippines versus the People's Republic of China concerning the South China Sea. Okay, this has been decided by the Permanent Court of Arbitration located in The Hague, Netherlands. Okay, so let's have a first brief background of the case. So on January 22, 2013, the Philippines instituted arbitral proceedings against China in a dispute concerning their respective maritime entitlements and the legality of Chinese activities in the South China Sea. In response, by a diplomatic note dated February 19, 2013, addressed to the Philippines, China expressed its rejection of the arbitration. Okay, later on we will discuss why China did not participate in the proceedings before the Permanent Court of Arbitration and why did it reject the award of the said arbitral tribunal. Okay. In China's view, the Permanent Court of Arbitration did not have jurisdiction in the case because China's acceptance of dispute settlement under the UNCLOS was limited and excluded sea boundary delimitations and the determination of historic titles. Remember, the claim of China here is that it has rights over its claims in the South China Sea because of historic titles. Because of historic title or historic right. That's their claim. That's their basis in saying that we own these portions of the of the South China Sea. Since then, China has continuously refused either to accept or to participate in the arbitral proceedings initiated by the Philippines. The PCA, however, did not see this as an obstacle. On October 29, 2015, it delivered its first award, finding that it had jurisdiction, and on July 12, 2016, its award deciding on the merits of the dispute. So what were the issues raised in this case? There are three main substantive issues raised by the Philippines in this case. Number one, the so-called 9-dash line and China's claim to historic rights in the South China Sea. Second, the status of certain maritime features in the South China Sea. And lastly, the legality of Chinese activities in the South China Sea. Unfortunately, the PCA ruled in favor of the Philippines in all these issues raised before it. But before we discuss the ruling PCA on these issues, let's first discuss what is this 9-dash line, okay? Because of jurisdictional limits, however, the PCA did not deal with matters related to territorial sovereignty over the disputed maritime features between the parties. That means that the tribunal did not decide who owned the maritime features located in the South China Sea, such as the Spratly Islands. So remember this one, the award of the Permanent Court of Arbitration did not decide who owns specific portions of the South China Sea, because that is outside their jurisdiction under the UNCLOS. They cannot determine who owns a particular territory or island or a portion of the South China Sea. Again, that is outside their jurisdiction. Okay? That are claimed by both China and the Philippines or any other coastal state in the region. Similarly, the tribunal did not delimit any maritime boundaries between the Philippines and China in the South China Sea. So, aside from not determining who owns certain portions of the South China Sea, the tribunal delimit any maritime boundaries. Okay? So, you remember that one. Again, because these are outside its jurisdiction. So, what are the highlights of the ruling of the PCA? On July 12, 2016, the PCA issued a long-awaited ruling in the Philippines case against China's claim in the South China Sea. The PCA invalidated China's claim to ill-defined historic rights throughout the 9-dash line, found that Scarborough Shoal is a rock entitled only to a 12 nautical mile territorial sea, and ruled on the legal status of every feature in the Spratly Islands raised by the Philippines. It found that none of the Spratlys, including the largest natural features such as Ituaba, Titu Island, Spratly Island, Northeast Cay, and Southwest Cay, are legally islands because they cannot sustain a stable human community or independent economic life. As such, they are entitled only to territorial seas, not EEZs or continental shelves. Of the 7 Spratlys occupied by China, the court ruled that Johnson Reef, Quarteron Reef, Fiery Cross Reef, and Given Reef are rocks, while Hughes Reef and Mischief Reef are below water at high tide and therefore generate no maritime entitlements of their own. Okay. It also ruled that Cannon Reef is a low tide elevation, while Second Thomas Shoal and Reed Bank are submerged and belong to the Philippine continental shelf. Taken together, these decisions effectively invalidate any Chinese claim within the 9-dash line to more than the disputed islets themselves and the territorial seas they generate. Okay, so what is this controversy or the controversy all about? At the heart of the South China Sea dispute is the 9-dash line. This has been the basis of China in asserting its rights over the South China Sea. Okay, historical rights by using the 9-dash line. Beijing's claim that the 9-dash line is Beijing's claim that encircles as much as 90% of the contested waters. The line runs as far as 2,000 kilometers from the Chinese mainland to within a few hundred kilometers of the Philippines, Malaysia, and Vietnam. Beijing maintains it owns any land or features contained within the line, which confers vaguely defined historical maritime Right. So if you look at the Chinese map, they have drawn 9 dashed lines. And according to them, all land features, water that are found inside the 9 dashed line are owned by them. Sabi nila, pag-aari daw ng China lahat ng napapaloob dun sa 9 dashed line. Kaso lang, the problem is the 9 dashed line runs as far as 2,000 kilometers from the Chinese mainland. So imagine gaano kahaba o kalayo o kalawak yun. In fact, that amounts to 90% of the entire South China Sea. And according to the Philippines, that is simply absurd. Why? Because that violates the United Nations Convention on the Law of the Sea. Because under the UNCLOS, each coastal state or each state are only authorized to generate up to 200 nautical miles from their baseline for their exclusive economic zone. That's the farthest that they could have, 200 nautical miles from the from their baseline. But imagine the claim of Beijing. It runs as far as 2,000 kilometers. You get it? It's times 10 of what is only allowed by the UNCLOS. And later on, we will discuss why it is very important for us to maintain our EEZ, our territorial waters, etc., etc. Because per maritime zone, there are specific rights wherein the UNCLOS grants to a state such as the Philippines. Okay? The Philippines is contesting the claims at the PCA. In its submissions, Manila argues the line exceeds the limits of maritime entitlements permitted under the UNCLOS. So what's the origin of this line, which is being used by China in invoking its rights in the South China Sea? It first appeared on a Chinese map. It appeared on a Chinese map as an 11-dash line. So originally, it's an 11-dash line. Mas malaki pa, mas malawak pa. But later on, binago yan at naging 9-dash line. As the then Republic of China's Navy took control of Siam Islands in the South China Sea that had been occupied by Japan during the Second World War. After the People's Republic of China was founded in 1949 and Kuomintang forces fled to Taiwan, the Communist government declared itself the sole legitimate representative of China and inherited all the nation's maritime claims in the region. But 2 dashes were removed in the early 1950s to bypass the Gulf of Tonkin as a gesture to communist comrades in North Vietnam. Okay, so out of a good gesture to their comrades who are fellow communists, the North Vietnam, they limited their 11-dash line to 9-dash line. So just imagine if they maintained that one, di ba? Kung gaano kalawak yung kanilang ino-occupy o kiniklaim. What is the importance of this 9-dash line and why is there a need to really question this one? It serves as the basis of China's claim to historical rights in the region, as neither Beijing nor Taipei ever held effective control over the entire region encompassing more than 2 million square kilometers. Other claimants such as the Philippines, Malaysia, and Brunei root their claim in geographical proximity. While Vietnam, which occupies the largest number of islands and reefs in the Treaties at 29, stresses it actively administers the area. The Philippines is challenging the legality of the line at the PCA. Our basis in claiming portions of the South China Sea of its proximity to the said area. Remember again, under the UNCLOS, you can claim your EEZ up to 200 nautical miles from your baseline. I get it? But for China, the 9-dash line, they're using 9-dash line as a basis for their historical rights in the region. So even if they are very far from the baseline of China, mabot ka ng 2,000 kilometers away, or nautical miles away, sinasabi nila they own the area because of some historical right. According to them, from the time of the Ming Dynasty, they have already been using and operating the said area, therefore, they own the said area. Okay? So, why is it important for us to maintain our EEZ? Sir, bakit hindi na lang natin hayaan sila na gamitin yan para wala na lang gulo, di ba? Yan yung sinasabi ng iba. Para wala na lang gulo, hayaan na lang natin ang China. Okay? China is very much powerful. Wala tayong labay na. But we have to maintain it not just because of sovereign issues, but also because of some practical reasons. So what are the rights of a coastal state like the Philippines in the East? Under the UNCLOS, a coastal state has sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters superjacent to the seabed and of the seabed and its subsoil, and with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water currents and winds. So, meaning to say, if the area belongs to your, or belongs or is within your EEZ, you have sovereign rights over the said area. Remember this one. The only right that we have over the EEZ is, again, sovereign rights. We don't have sovereignty. Meaning to say, we don't own it, the said area. We only have sovereign rights. When we say sovereign rights, we have the right, the exclusive right of exploring and exploiting, conserving, and managing the natural resources in the said area. And you know how rich the said area is. This could, if it's fully explored and the resources here are utilized properly, this could what? Lift the Philippines from poverty. You get it? Okay, so again, in the EEZ, we only have sovereign rights. We don't have sovereignty in the EEZ. We only have sovereign rights, which covers what? Exploration, exploitation, conservation, and management of the natural resources. Okay? Also, jurisdiction as provided for in the relevant provisions of the UNCLOS with regard to the establishment and use of artificial island installations and structures, marine scientific research, the protection and preservation of the marine environment, and other rights and duties provided for in the UNCLOS. So, aside from the exploitation, exploration of the natural resources in the area, you also have jurisdiction as regards this one. Okay? So these are the rights of a coastal state in the EEZ. Okay. So again, a while ago, we've said that China has been contesting, or sorry, has contested the jurisdiction of the PCA. In fact, not participated because according to them, the PCA has no jurisdiction over the, according to China, the issues presented by the Philippines touch on the issue on ownership or sovereignty over the said area. Since it questions sovereignty or ownership of islands in the West, in the South China Sea, therefore that is outside the jurisdiction of the Permanent Court of Arbitration. Okay, so that's the argument of China. And China also raised another argument. According to China, other indispensable parties were not pleaded in the said case, like Vietnam, Malaysia, Brunei, etc. Therefore, PCA has no jurisdiction. Lastly, according to China, the PCA has no jurisdiction because it means that any controversy involving the West Philippine Sea should be solved bilaterally. Bilateral negotiations or agreement between the parties. Since there is already an agreement that divests the Permanent Court of Arbitration of jurisdiction over the case. So these are the three jurisdictional questions raised by China in questioning the jurisdiction of the PCA. Okay? Sabi dito, the essence of the subject matter of the arbitration is the territorial sovereignty over several maritime features in the South China Sea, which is beyond the scope of the convention and does not concern the interpretation or application of the convention, because the PCA can only have jurisdiction if the issues raised are regarding the interpretation or application of the convention, meaning to say the UNCLOS. But if it talks about the determination of who owns or who is the sovereign in the said area, UNCLOS or the PCA has no jurisdiction on that. Okay? Ito yung sinasabi ko kanina that according to China, an agreement has already been entered between the Philippines and China regarding the conduct of parties in the South China Sea. Declaration on the conduct of parties in the South China Sea. Therefore, this settled their relevant disputes through negotiation, meaning to say, according to them, they cannot unilaterally initiate a proceeding, an arbitration proceeding before the PCA. Sabi nila, it has to be agreed upon by China and the Philippines. Okay? Okay, so these are the issues raised by China in questioning the jurisdiction of the PCA. Sorry. Okay, but did the PCA rule in favor of China as regards the jurisdiction questions raised by China? Answer, obviously, no, right? That's why eventually the PCA decided the case in favor of the Philippines. Okay, as regards the question on sovereign issue. According to China, PCA has no jurisdiction because this talks about the question raised by the Philippines focuses on sovereignty. According to the PCA, no, it's not. We are merely interpreting and determining the applicable provisions of the UNCLOS as regards your dispute. Therefore, we are not going to talk about sovereignty issues on the matter. In fact, if you read the award, the PCA did not declare who owns the disputed islands or waters in the South China Sea. They merely focus on the what? On the extent of the claim of China, if it is indeed consistent with the UNCLOS. If the 9-dash line and the historical rights of China is consistent with the provisions of UNCLOS. As regards the issue raised by China that there has already been an agreement between the Philippines and China regarding the code of conduct in the South China Sea. Therefore, the PCA has no jurisdiction. Sabi ng PCA, no. The code of conduct is a mere political agreement and not legally binding. It does not provide a mechanism for binding settlement, does not exclude other means of dispute settlement. So sabi nila, it's a mere political agreement between the Philippines and China, which does not divest the PCA of its jurisdiction over the matter. In fact, if you look at the code of conduct, sabi ng PCA, it does not talk about an exclusive mechanism to settle dispute between two countries. Therefore, it does not exclude other means of dispute settlement. Therefore, the Philippines can avail of the dispute settlement mechanism under the UNCLOS by going to the Permanent Court of Arbitration. And lastly, as regards the argument of China, both parties were not included. According to the PCA, although they have not been included, but the parties did not raise any objection. In fact, Vietnam even agreed, sabi ni PCA, since the other parties did not object to it, and Vietnam even agreed to the filing of the case before the PCA. Therefore, the argument that indispensable parties are not properly impeded does not stand according to the PCA. Okay, let's now discuss the ruling of the award rather of the PCA on the different issues raised by the Philippines. Okay. Sorry. As regards the 9-dash line and the alleged Chinese historic rights, What did the PCA say about this? The tribunal dealt with the question whether China's claim to historic rights within the 9-dash line were in conformity with the UNCLOS. It first observed that this area in which China claimed rights formed in the long historical course to living and non-living resources partially overlaps with areas that would otherwise comprise the exclusive economic zone or the continental shelf of the Philippines. In the view of the tribunal, the